Hello viewers, this is Mr. By.Yasin Shakir Advocate and you're watching my YouTube channel Nai Soch Nai Manzil. In another video, I cordially welcome you to another video that is on the topic of competent witness or competency of witnesses. The persons who are competent to be a witness. Let's define what actually a witness, competent witness is. A witness is competent if nothing in law to prevent him from being sworn in and examined if he wishes to give evidence. It is a general rule. Everybody is competent to give evidence. And if we talk about an Islamic version, every witness is bound to come and give testimony. This is actually the order from Islamic point of view. Relevant provisions that actually deal in Qanun-e-Shahadat Order 1984 QS. So the Article 3 actually it deals with qualifications and disqualifications of a witness, and this is our topic of discussion today. And Article 17 it deals with the number of witnesses in a particular case. How many witnesses are needed? So first of all, let's discuss the qualifications. First qualification of a witness is understanding. He should have the ability of understanding, ability to understand the question. There should not be any problem relevant that he or she might not be able to understand the question, the nature of question. There may be the problem of tender age, old age, or maybe some sort of disease related to body or related to mind. There should not be such sort of situations. The second one, here the witness should have rationality. He or she should be able to rationale, to understand and give rational answers to the questions asked to the witness. The third one, convicted of perjury. There shouldn't be such situation that a witness is who is going to give testimony is convicted of perjury. Perjury means a false statement that is given before a court and betrayed that court. But there are exceptions. A convicted person of perjury can be a witness in the cases where the court satisfies itself, or the person actually him or herself can actually avoid the ways that he or she had done in the past. Not an interested witness. An interested witness means a witness that is interested and that is bribed one. Fifth one, no female in hudud cases. In hudud cases, there shouldn't be a female witness. Capacity to understand the oath obligation. The witness should be able to understand the obligation that he or she is going to perform, the obligation of oath. Quran and Sunnah and Islamic jurists. What actually Quran and Sunnah says and Islamic jurists have derived from the Quran and Sunnah. First, the witness should be rational. Second, he should have eyesight in the matters where eyesight or the seen matters are there. Third, in hudud cases, communication and speaking ability should be there. No perjury should be there. Not interested witness. The witness should not be interested as is discussed earlier. Same religion. The witness should be of same religion because, for example, if there is a Muslim suit that is filed and a Christian is not a valid witness for a Muslim or Muslim Islamic religious suit. Conditions for testimony. What are the conditions that are necessary for giving testimony? There should be an existence of complaint. Complaint should be there. And before the testimony should be given before the court. Personal knowledge should be there. But hearsay evidence is also admissible if there is the admissibility of the hearsay evidence. Word shahadat should be used while giving the testimony. Remembrance of incidents. The witness should remember actually the whole incident. Identification of parties. The witness should identify and should have the ability to identify the parties on whose behalf he is going to give the testimony or whom against he is going to give the testimony. Confirmation of statement. The statement that he or she himself is going to give should be based on some sort of claim, not at distance in hudud cases. In hudud cases, there shouldn't be any sort of distance. The witness should be at the time of occurrence of the incident. Voir dire, preliminary examination should be there. The witness should be brought into the witness box. Tazkir Shahood should be there. This is the process to know the competency, righteousness, and purgatory statement is always there to make the person able to give the testimony. This was all about for today's video, and this was about the competency of a witness. In upcoming videos, we'll discuss more about this. Thank you for watching this video.